Hi there, my name is Stephen Marshall, and my team and I are excited to work with you on your eviction case. This video's got some important information that will give your case the best chance of success. So please watch this video before asking us to file your eviction case, as your case may not be ready for filing just yet. And if you have any questions, do not hesitate to contact us. Evictions have gotten a lot more complicated over the years. Instead of one tenant attorney in the area, Lexington now has sometimes as many as 6 tenant attorneys and several other tenant advocates who set up shop at the courthouse looking over tenant cases, looking for loopholes that will give the tenant more time that you're going to be without money if your case isn't filed correctly. So I'm going to go over a few areas that often trip landlords up when it comes to their eviction cases. Number one, make sure that you name all the tenants and occupants. Give us the names of all adults that are listed on the lease and any other adults that you know to be residing in the property. We want to cover all the bases, make sure we get everyone out of the unit. Number two, we've got to identify the proper owner. Evictions must be filed in the name of the owner as it's listed on the deed to the property, whether that's a person or a company, okay? Filing the case in the name of the wrong owner could cause a delay or the dismissal of your case. We're going to look up the owner on the PVA's website, but that website isn't always up to date with current information. So please let us know if there's been a recent sale or purchase of the property that might not yet show up on the PVA site. Number three, you've got to nail your notice. You've got to get your notice right. In Lexington, Louisville, Georgetown, Covington, and other areas that have adopted the Uniform Residential Landlord-Tenant Act, the law allows for a 7-day notice to pay or vacate for tenants who are behind in their rent. However, that law does not apply in Jessamine County, Woodford County, Clark, Madison, or Boyle counties, or any other city or county that has not specifically adopted the Landlord-Tenant Act. In those counties, your lease dictates how much notice must be given before filing the eviction. If your lease in those areas does not specify how much notice has to be given, the courts are typically going to require 30 days notice. So make sure you give the notice that is authorized either by the law or by your lease. Fourth, and this is a big one that I've been covering lately, the CARES Act. Unless Congress takes some type of action in the future, properties in Lexington that are covered by the CARES Act are going to need to give 30-day notices to pay or vacate for tenants who are behind on the rent, rather than a 7-day notice. For a refresher, the CARES Act covers any property that has a federally backed mortgage, such as with Fannie Mae, Freddie Mac, or the FHA, or any property that receives any type of federal assistance, subsidies, or tax credits, including Section 8 vouchers. Now, in the case of Section 8 vouchers, the CARES Act would only apply to the individual unit that receives the voucher, not necessarily the whole building or the whole community. There are several databases linked on my website that you can search to see if your property has a federally backed mortgage, and if it does, you need to give a 30-day notice, not a 7-day notice. Fifth, deceased tenants. If your tenant is deceased, your eviction must be filed against either the estate of the tenant or the heirs of the tenant. Most of the time, no one is going to open an estate for the tenant, although it does happen. So that means most of the time, the case is going to be filed against the unknown heirs of that tenant. Most of the time, it's going to be for non-payment of rent after proper notice has been given. So, make sure to let us know when your tenant is deceased, even if that occurs after the case is filed, because we would need to amend the complaint and we don't want to have your eviction case delayed. So let us know if your tenant is deceased. Number 6, partial and late payments. The law never requires you to accept a partial payment or a payment that's offered after the notice to pay or vacate has expired. However, the law does require you to reject such payments if you want to proceed with an eviction without giving a new notice. Recently, courts have ruled that anything other than an immediate rejection of certified funds constitutes an acceptance of that payment and thus eliminates your ability to evict that tenant without giving a new notice. So, unless the tenant is coming to you with enough money that you're fine to allow them to stay longer, do not take that payment, even if you don't deposit it. Some folks like to take the payment and they hold it until court or until maybe the tenant can come back with more money. Don't do that. Unless the amount that they give you is enough that you're willing to let them stay until you can give a new notice, give them the payment back to them immediately. Do not delay. Number 7, subsequent notices. Once the notice to pay or vacate has expired and you wish to evict your tenant, do not give any more notices. There's a case from 1907 that holds that attempts to collect rent reinstate the tenancy. Now, there's an argument that that only applies to attempts to collect future rent, but courts have yet to clarify that. So for now, once your notice expires without compliance by the tenant, do not send any more notices. Doing so puts your eviction in jeopardy. Number 8, interpreters. If you believe there's any chance that your tenant needs an interpreter, let us know when you send the case over to be filed. We can request an interpreter and your case won't get delayed. But if we don't request that interpreter up front, your case could get delayed for a week or more because the tenant requires an interpreter on the date of the hearing. So let us know up front if there's any chance your tenant needs an interpreter. Now, please understand, your tenant may speak some English, may speak decent English, but if English is not their native language, okay, and if they're not fluent in English, there's a good chance that they can show up to the court hearing, request an interpreter, and have the case delayed. So if there's any chance your tenant is going to need an interpreter, let us know that when we file the case so that we can request it for your hearing date. All right, court hearings. Here are some tips that will help make everything go smoother. First, make sure you bring the entire tenant file to court. I know that can be a drag if you have 10 cases, but make sure you bring it. At a minimum, we're going to need the lease, the notice, and an updated payment ledger. Now, you may have been to court 10 times in the past and you ended up not needing any of those things. The 11th time that you show up, you're going to need it, okay? So bring those things to court. Otherwise, you run the risk of your case getting delayed or dismissed if you don't have that information to present to the court at your hearing. Next, make sure the person who delivered the notice is present in court, okay? That person is the only one who can testify, who can swear under oath that the notice was actually given. If you didn't see it given or you didn't give it yourself, you can't testify under oath that it was given. Third, please show up 10 to 15 minutes early to check in with your attorney, maybe me, maybe another one of my colleagues, to discuss which cases need to move forward and which should be dismissed or continued, okay? Now, that's not the time right before court to have extended discussions about some type of abnormality in the case, okay? We're not going to have much time. We just need to know, do you need judgment on your case, or has the tenant paid? Has the tenant moved out? Are you working with the tenant and want to give them more time? Those types of things. Extended discussions should take place prior to the day of court when possible. Next, you're going to have to testify at your court hearing most of the time. When it's a non-payment of rent case, you're going to need to testify about your position at the property. Typically, you're going to be a property manager or assistant or a leasing agent or a bookkeeper, maybe even the owner, but you'll testify about your position there. You'll need to identify the owner of the property. You'll need to be familiar and be able to testify about the tenant's lease, the details of the tenant's breach of the lease, whether that's non-payment of rent or otherwise. You'll need to be able to testify as to when and how the notice was given to the tenant. And you'll need to testify about the details of the notice, okay? The date of the notice, how much was due, that type of thing, and how long the tenant was given to comply. And then finally, you'll need to testify about the tenant's failure to comply with the notice, including any details about any payment efforts by the tenant. Okay, Those things will help you be prepared on hearing day. Now, let's talk about non-compliance or lease violation cases for a minute. These cases have gotten very difficult to win. So here are a few things to keep in mind before you file your case. First, not all lease violations are grounds for eviction. Okay? Instead, material non-compliance is required. And that is typically defined as serious or repeated violations of the lease or the law that affect the health, safety, welfare, or peaceful enjoyment of the premises by other residents. Okay? Material non-compliance. Next, do not accept rent after you learn of a lease violation that you wish to evict for. Now, this applies even to other violations beyond non-payment. Okay? The law provides that accepting money after you learn of a violation waives your right to evict for that violation. So if it's something you want to move forward on, do not accept money until the tenant has corrected that violation. And if they don't correct the violation and you want to move forward with the eviction, do not accept money at all. Third, you bear the burden of proving that the tenant actually did what you're accusing him of doing. Okay? The onus is on you. You're the one that's bringing the case. So you bear the burden of proof. Fourth, you can only testify about what you've seen or heard or smelled. Okay? That means you may need to get other witnesses to testify at the court hearing. Maybe other residents are the ones who saw the tenant doing what they've been accused of doing. Maybe it was a police officer. Maybe it was someone else. Whoever it is needs to be in court because they're the only one that can personally testify as to what happened. And we can subpoena them if needed. Next, remember that arrests and police calls are not evidence of wrongdoing sufficient to support an eviction. Okay? We would need either a conviction or some type of direct evidence that the tenant committed a crime. An arrest doesn't do it, a police call certainly doesn't do it. And then finally, notices for these kinds of cases must be sent by a certified or registered mail or putting them in the tenant's hand. Okay? Posting on the door, taping to the door, sliding under the door, that doesn't work for material non-compliance cases. You need to send it either certified or registered mail or put it in the tenant's hand, one of those two types of methods. Next, month-to-month tenants. The law only allows a month-to-month tenancy to be terminated at the end of a rental period. Okay? If the tenant pays rent on the first day of the month, as most do, the rental period ends at the end of the month. And so as a result, your termination notice for a month-to-month tenant must give them until the end of a month that's at least 30 days away to vacate. It's not a straight 30-day notice necessarily unless you happen to give it on the first day of the month. Next, non-renewals. The law requires you to have a legitimate business reason for not renewing a lease or a month-to-month tenancy. That reason must not be discriminatory or retaliatory. Okay? Retaliation means that you're not renewing the tenancy because the tenant has made maintenance requests or otherwise asserted their rights as a tenant. Legitimate business reasons for non-renewal include you're selling the property and you need it empty in order to sell it. The property needs renovations and you need the tenant to be gone in order to perform the renovations, or other lease violations by the tenant that you've given them notice about during the tenancy. Okay? If it wasn't enough during the tenancy for you to give them notice about, then it's probably not enough at the end of the tenancy to non-renew them over. Okay? So lease violations during the tenancy that you gave them notice about during their tenancy. So thank you again for working with us. If there's anything in here that you have questions about, please reach out to us before we file your eviction case. All right, that will give you the best chance of success. We want to get these things right on the front end so that on the day of court, we just go through the process, we get your judgment, and the clock starts ticking on getting your tenant out. If you got any questions, always please reach out to me or my staff. Thank you so much for working with us, and I look forward to seeing you.